Mr. Banner, I hope you can hear me. I sent my closing about 5 minutes ago to Mr. Drury, so hopefully you have that.
I don't actually know. I think emails are taking a little while to come through.
Right, do you want me to send it to you direct? Would that help?
If you wouldn't mind sending it direct, I think you've got my email from the other correspondence. That'd be great. Thank you.
Yeah. Give me one moment.
It's just arrived actually, so
fine.
Send it anyway, and then they'll get me to me.
Yeah. Can you see me?
Yes.
Oh, fine. Yeah, because I can't see myself. But, yeah. And I've just got your response. Yeah, the costs. Yeah.
Yes.
Thanks. Yeah.
Go camera while I finish my breakfast in the last minute.
Yes.
Good morning, everyone.
Good morning, sir.
Good morning.
Hello, it's 9:30 and the inquiry is resumed. Final day today. We've now concluded all of the evidence from the parties, and all that remains are the closing submissions, and there's a costs application to be dealt with as well. And after that, I'll make some arrangements for the site visit, which should occur this afternoon. So are there any other matters that need to be raised at this point before I hear closing submissions?
No, sir.
Okay, thank you. I haven't received a written version of closing submissions yet, Mr. Smythe. Is that in hand?
Yeah, it was sent about 8 minutes ago to Kerr and Helen Skinner.
Right, okay. It should hopefully then work its way through to me shortly. Just let me just check. Right, okay. I think that is on its way to me. So, Mr. Smythe, you've sent that to the appellant already, have you? You've got that, Mr. Banner? Yes. Okay, that's fine. Well, if you want to start and it will come through to me, and that's fine. I can listen to what you're saying.
Yes, sir. It's short. I don't think it will take much more than 15-20 minutes.
Right,
this is a relatively straightforward appeal, and so the council's submission shall be short. Why? It's common ground that 1, if the tilted balance applies, the appeal should be allowed. 2, the inspector has the benefit of 2 recent inspector decisions, which grapple with some of the very same issues that occupy this inquiry, and that they represent material considerations of weight and importance. And thirdly, the locational strategy is one of the most important things that any development plan does. And in this district, to quote Mr. Hill, its locational strategy is one of the fundamental parts of the local plan. This opening shall be structured by answering a number of key questions, which it is respectfully submitted lead you, sir, to the correct conclusion. So question number 1, can the council demonstrate a 5-year housing land supply? So doubtless you have taken a good note of what was said during the course of the roundtable discussion, and it's not considered helpful to recite it here. The council is happy to leave it in your hands, save for 1 point. On the morning of day 3, the appellant sought to change its case on housing land supply by subtracting a further 31 units from the housing land supply in respect of the site at Mearside Station Road, Soham. This is a NPPF Category A site, as it has the full benefit of planning permission. This attack was not contained within the housing land supply statement of common ground, Mr. Ostenfeld's proof, Mr. Ostenfeld's rebuttal, or the agreed housing land supply position paper, which was agreed on the morning of the first day. It's a new point. The appellant ought not to be allowed to add this point after the close of the council's case. So you were strict with the council and restrained me from presenting evidence which went beyond my written case, both in respect to the oral evidence of Mr. Kay and the oral evidence of Miss Greengrass on days 1 and 2. It would be unfair if a more permissive approach would be afforded to the appellant. What is sauce for the goose is sauce for the gander. The fact that the appellant misunderstood the relationship between the 2 bits of the wider site provides no excuse. The appellant would be the first to criticise the council if it went behind a concession agreed on the face of the statement of common ground. And so in support of that, you may recall Mr. Banner's heat intervention when I took Miss Greengrass to the design and access statement in evidence in chief. In the event, sir, that you do allow this change of case, it's submitted the appellant has provided insufficient evidence to discharge its burden of showing that this site is not deliverable. Next question is Grove 2 out of date. The contention that the fact that Grove 1 is out of date and subject to review renders Grove 2 out of date has been ventilated at recent appeals. The council could be forgiven for having a strong sense of déjà vu. This very point has been ventilated at multi-day hearings where other housing developers have run the very same argument. It has failed twice. Both Inspector Searson and Inspector Chamberlain rejected the appellant's argument that Grove 2 was out of date because Grove 1 was out of date. This is also a point raised in respect to the examination of the Wychford neighbourhood plan. Developers at that examination argued that Grove 2 was out of date because Grove 1 was out of date. The examiner rejected this argument, and so you should take the same view. The next question, as Grove 2 is not out of date, what weight should be afforded to the conflict? The heart of Mr. Banner's cross-examination of Miss Greengrass was a point that the appeal only offended the letter of Grove 2, as it did not contravene the 2 purposes of the policy. This was somewhat of an ambush. It is not a point raised clearly in the appellant's statement of case or its written evidence. The appellant's planning evidence on Grove 2 is found at paragraphs 5.1.7 through to subparagraph 28 of Mr. Hill's proof. So you will struggle to find that point, i.e. the appeal only offends the letter of the policy, not its underlying purposes, in the proof. One can find passing reference, and it really is a passing reference, in 1 paragraph of Hill's rebuttal proof. This is surprising. This is not some incidental part of the appellant's case. It appeared to be the major point of Mr. Banner's cross-examination. It's disappointing that a point which forms the heart of the appellant's planning case on the development plan was not expressed clearly in its written evidence, but dropped in cross-examination. That said, the point is built on sand. The whole premise that there was only 2 purposes to Grove 2 is not explicit on the development plan. Mr. Banner draws out the expression having regard to and infers that this means that they are the 2 purposes. Weight, sir, is quintessentially a matter of planning judgment. The appellant is at pains to emphasise that Inspector Chamberlain did not give Grove 2 full weight. That does not mean that Grove 2 should only be given limited weight. Significant weight should be given to this policy. Why? An important factor which bears on the weight to be afforded to Grove 2 is the presence or otherwise of the housing land supply. If there's a housing land supply shortfall, it follows the settlement boundaries are out of date, and they would inevitably need to flex to release further greenfield sites to boost supply. But if there's not a housing land supply shortfall, it follows that the settlement boundaries are up to date, and they would not need to flex to release further greenfield sites. Mr. Hill agreed in cross-examination that Grove 2 was not an incidental policy, but was, and I quote, a fundamental part of the development plan. The appellant criticised the council for only reviewing Grove 1 and failing to review Grove 2. That is unattractive. The council is the democratically accountable local planning authority. It decides how to draw up its development plan, not the appellant. It forms no part of your role, sir, to second-guess the plan-making process. This was an issue which was expressly addressed by Inspector Chamberlain. And so I quote that, and I shan't read it out. Contrary to Mr. Hill's view under cross-examination, it's plain that Inspector Chamberlain's view on Grove 2 was tentative rather than firm. It is implicit that it was his opinion that it was too soon to reach conclusion, i.e., if Grove 1's housing requirement is only modestly uprated, it would not materially impinge on Grove 2. The council agrees. In the fullness of time, it's acknowledged that Grove 2 could be rendered out of date, but it's premature to reach that view now. And so that is why Inspector Chamberlain states the council are in the process of reviewing Grove 1 to assess this. And the assess this bit is the outdatedness of Grove 2. So next question, does the appeal conflict with the development plan as a whole? It's common ground that the appeal offends Grove 2. Given that this policy goes to the heart of the spatial strategy of the local plan, common sense suggests that if the appeal is contrary to Grove 2, it's contrary to the development plan. The appellant says otherwise. Directing the locational strategy of an area is the number one thing that any development plan does. It is a very, very important objective of any development plan. For the appellant to say that the appeal only offends Grove 2 is a bit like saying Usain Bolt is only good at sprinting. Grove 2 is not some incidental policy. As Mr. Hill agreed in cross-examination, it's one of the most important policies of the development plan. It's common ground that there are 47 main policies, together with the housing and allocation policies. Grove 2, it is submitted, stands at the top of the tree. Setting settlement boundaries is an important component of Grove 2. The policy seeks to jealously protect the countryside of this rural district out with the settlement boundaries, which do not fulfil the exceptions. That is how the council, reflecting the wishes of local people, has chosen to plan for the district. This is an expression of the government's imperative that the planning system should be genuinely plan-led. In arriving at this, the council has adopted a very important planning judgment. In doing so, it has the full support of national policy. The council submits the appeal offends the development plan as a whole. Next question, do other material considerations relied upon by the appellant render the appeal sustainable development, notwithstanding what is characterised as a technical breach of the development plan? The appellant relies upon three matters, which it is agreed are relevant, but in the council's view are not worthy of significant weight. Why? Firstly, sir, the Soham Master Plan, it's not a DPD, SPD or LDD. It was adopted, quote unquote, in 2010, thereby predating the NPPF. This antiquity diminishes its weight. Secondly, sir, the existence of the withdrawn plan. The site was not properly scrutinised as it was not subject to the further consultation required. There were astounding objections which had not been interrogated, let alone resolved. Thirdly, the broad locations in the explanatory text accompanying Grove 4. Mr. Hill agreed in cross-examination that the broad locations are not contained anywhere within the policy itself, nor is there any reference to them within the policy itself. The broad locations are plainly identified in highly tentative terms. In respect to Soham, the local plan states, and I quote, that further investigative work on site suitability will be needed. And earlier it said that development could come forward in the latter part of the plan period. As there is still 9 years left of the plan period, it is premature to give significant weight to this point now. So next question, do the benefits of the appeal override the conflict with the development plan? It's right to say that because the appeal offends the development plan, it's not the end of the story, but it is an important milestone. The council has gone to the trouble and expense of drafting and adopting a development plan. As Miss Greengrass stated in cross-examination, breaching the development plan is a big deal. So I then quote paragraph 12 of the framework, and I shan't repeat it here. This is a clear indication on the part of government that approving development contrary to an up-to-date development plan is the exception rather than to be regarded as commonplace. One should not grant planning permission for development which offends an up-to-date development plan lightly. This is particularly the case when Mr. Hill, I think I've got his initials wrong, sir, Mr. Hill agreed in cross-examination the locational strategy of Grove 2 was one of the fundamental parts of the development plan. The onus rests on the appellant's shoulders to satisfy you that you ought to depart from the usual position. It's not the council's case that NPPF paragraph 12 displaces or overrides the statutory test, but it does give a clear steer as to how one should approach the planning balance in circumstances where a proposal is contrary to an up-to-date plan. The provision of affordable housing, which modestly exceeds the policy minimum, and self-build offer are important benefits which are welcomed. It's common ground that there are a number of significant benefits which weigh in the appellant's favour, but it's admitted they are not so potent as to outweigh the conflict with the development plan. It has been a recurring theme of the appellant's case. The appeal can only be said to cause quote-unquote policy harm rather than quote-unquote real-world harm. So that is a contrived and unhelpful distinction. The settlement boundary around Surham is not simply a line on the map drawn at the whim of a planner. It marks the end of the built environment and the start of the countryside. Policy harm causes real harm on the ground. The fact that the council did not consider the proposal gives rise to an unacceptable impact on character and appearance of the countryside, so as to founder a freestanding landscape reason for refusal does not mean that material harm is not caused. So, sir, in conclusion, the council says the proposal is not sustainable development and you are invited to dismiss the appeal.
Right, okay, thank you for that, Mr. Smythe. Just going to my emails now to check I've got your closes, Mr. Banner. I think I have.
Anticipation, it might take some time. I pinged it over about 10 minutes ago, sir, so hopefully it's made its way through.
Yes, I've got it. Thank you.
Thank
When
you.
you're ready, please.
Thank you. So I first of all start with the tilted balance scenario. As the council now accepts that the appeal should be allowed in the event that the tilted balance under paragraph 11D of the framework applies, it's logical to start here. And the appellant submits that the tilted balance applies for either or both of the following reasons. Firstly, that the council is unable to demonstrate a 5-year housing and supply, and or secondly, the most important policies for determining the appeal are out of date. In relation to 5-year supply, the appellant's case is summarised in the updated position statement submitted yesterday afternoon. And for the reasons set out there and elaborated by Mr. Ostenfeld in his written and oral evidence, the true position is the council can only demonstrate a 4.89-year supply. The council, as I'm bound to say, at times somewhat crowing refrain that even on the appellant's own case, the housing supply isn't much below 5 years, fails to appreciate, sir, that this reflects the reasonableness of Mr. Ostenfeld's professional judgments on the issue, preferring himself to adopt a moderate and pragmatic approach rather than an extreme hard line. And I suggest that this is to be contrasted with the council's evidence in relation to housing and supply, which repeatedly struck an arrogant and complacent tone. Even if, contrary to our case, the housing supply is above 5 years, on any view, the council's previous claim that it was a healthy 7.02 years has proved to be a very considerable overstatement, which has led the council materially to downplay the weight to be given to the contribution the scheme would make to boosting significantly the supply of housing in a district where that supply is at best somewhat precarious. As for whether the most important policies are out of date, I make a number of points, sir. Firstly, Ms. Greengrass explained in evidence in chief and confirmed in cross-examination that her approach to assessing which of the policies agreed in the main statement common ground to be relevant were also most important. And for her, the litmus test or filter was whether the policies in question were determinative or decisive. She used those words interchangeably. And yet, when this approach was tested in cross-examination, she was unable to point to anything in the framework, previous appeal decisions, or case law which supported the application of such a test. And similarly, in cross-examination, it was put to Mr. Hill on behalf of the council that he had wrongly included within his broader basket of most important policies those policies which were merely neutral, the word used by Mr. Smythe, neutral, as opposed, we must assume in light of Miss Greengrass, to being determinative or decisive. So Miss Greengrass didn't follow through her own logic, because her basket of most important policies includes a number of policies which are, on the council's case at this appeal, neither determinative nor decisive, but neutral. HOU 2, 3, ENV 1, 2, 9, and the Minerals and Waste Plan Policy 16. Following the withdrawal of all reasons for refusal other than the first, the only policy that the council itself suggests is determinative and decisive as opposed to neutral is growth 2. So if you were to adopt the council's approach to the filter, to assessing which policies are most important policies, determinative or decisive as opposed to neutral, the conclusion you ought to reach is that there's one most important policy, and it's growth 2, and that's the only one. The alternative is Mr. Hill's wider basket of most important policies set out in full, and it should be accepted in full. There's no coherent midway point at which to draw the line. It's either Mr. Hill or the narrow approach of the council, which leads to just one MIP. And the only MIP in relation to which there was a debate during the inquiry as to whether it's out of date or up to date was that one, growth 2. So it may well be whichever approach you take, that issue really determines whether the MIP is out of date or not. That really goes to the heart of it. And so the council's case on whether growth 2 is up to date or out of date erroneously treats the two Witchford decisions of Inspectors Searson and Chamberlain as having binding force unless there's been some change of circumstances. And that's misconceived. You aren't bound by those decisions, and you are free to disagree with them, provided you explain why. I start by noting that both decisions consider it's only on balance that growth 2 is up to date. Well, firstly, so in this respect, we endorse Inspector Chamberlain's comments, paragraph 54 of his decision, that growth 1 is out of date because the housing requirement it specifies is out of date. He went on to say this may have infected the entire spatial strategy, including growth 2, because settlement boundaries may be too tightly drawn. Housing may be directed to too few settlements. There may not be enough allocations. The council in the process of reviewing growth 1 to assess this. They are currently unable to demonstrate a 5-year supply. That's probably despite instead of policies growth 1 and 2. Can I add there, so as an aside, my learned friends' repeated emphasis on the word may is suggesting some tentativeness about that. It is straying into the forbidden territory of reading inspectors' decisions like they were statutes or contracts, which the court repeatedly deplored. It's plain that Inspector Chamberlain was expressing doubt about the up-to-datedness of growth 2. And indeed, that is also clear, this is my point G, from the fact that Inspector Chamberlain considered that this tempered the weight to be given to the conflict with growth 2 in that case. At paragraph 75, he said only moderate weight for that reason. So it's very clear that it was a conclusion with some consequence. Turning over the page, if Inspector Chamberlain's logic is followed through, however, so as we say should be done in this case, the unavoidable conclusion that follows is that growth 2 is out of date. And as to this, I make some particular points here. The suggestion that growth 2 is saved by the fact that it has an extensive list of exceptions, which is what Inspector Chamberlain saw as tempering that observation I highlighted a moment ago, and it was also the key point for Inspector Searson. That suggestion fails to appreciate that in relation to housing, and it's the housing which is the type of development in relation to which growth 2 is infected by the out-of-dateness of growth 1. In relation to housing, there is no meaningful exception for market-led proposals. Replacement dwellings won't make any meaningful contribution to housing supply. And there's evidence that wasn't before the last two inspectors, but is before you, evidence from Mr. Hill, not challenged in cross-examination or gainsaid in closing, which notes that district-wide only 17 dwellings per annum come forward under the exceptions to growth 2 over the last 20 months. And indeed, Mr. Hill also noted no 100% affordable schemes have come forward and so on pursuant to the exception for that policy. So contrary to what those previous inspectors found, uninformed by the evidence Mr. Hill brings to inform you, the conclusion should be that the housing-related exceptions to growth 2 are in truth highly limited. And secondly, sir, whilst the framework of paragraph 170b refers to the objective of recognising the intrinsic character and beauty of the countryside, the framework plainly doesn't preclude, in principle, market-led housing schemes in any countryside location, irrespective of the impact. Growth 2 does, the framework does not. And therefore, growth 2 cannot be saved from out-of-datedness on the basis it is on all fours with the approach taken in the framework to countryside development. And Inspectors Searson and Chamberlain were, to be frank, wrong to conclude otherwise. And so accordingly, the proper conclusion is that growth 2 is out of date, and so too is the basket of most important policies, whether the basket includes just that policy, as must be the conclusion on the Council's approach to assessing their most important policies, or the wider range of policies, including Mr. Hill's basket. And so for any of those reasons, the tilted balance applies, and on that basis, it will be common ground the appeal should be allowed. Next, I'll deal with conflict with the letter, but not the purposes of growth 2. And so this point is capable of being relevant both to accordance with the plan as a whole and to the assessment of whether other material considerations outweigh any non-accordance. I deal with it under its own freestanding heading. Before I make my point, sir, I was surprised to learn that Mr. Smythe thought that this wasn't a point that was made in the evidence. The version of Mr. Hill's proof that I have deals with the purposes of growth 2 explicitly under its own heading on page 42, 5.1 to 0.7 through to 5.1.18. And then having dealt with the purposes, then there's consideration of harm to those purposes at 5.1.19 to 5.1.28. And there is also in the rebuttal, as well as the paragraph Mr. Smythe mentioned as paragraph 1.1.30 takes the point too. So it's a complete mischaracterization to say this is a new point or something which didn't have emphasis. It was always been central to our evidence. Now, turning back to the script at paragraph 8, sir. The appellant accepts that the proposed development will conflict with policy growth 2, and specifically the 4th paragraph of that policy, the relevant part of which provides outside defined development envelopes, development will be strictly controlled, having regard to the need to protect the countryside and setting of towns and villages. Development will be restricted to the main categories below. And the appeal site is outside the defined development envelope and not within one of the categories in the list that follows the words quoted above, and hence necessarily it is in conflict with the letter of this part of policy growth 2. But it's vital, sir, however, to consider whether it would also be in conflict with the purposes of that strict control. And those purposes are set out expressly in the policy, having regard to the need to protect the countryside and the setting of the towns and villages. And the supporting text at paragraph 3.3.5 further states that having regard to the reference to the framework to intrinsic character of the countryside, development envelopes have therefore been drawn around the main built-up areas of the market, towns and villages in order to prevent sprawl into the open countryside and protect the character and setting of settlements. And the same paragraph concludes that a more compact form of development is also more sustainable as it promotes easier access to jobs and services. And so, sir, it's therefore plain that the purposes of the strict control in the part of growth 2 with which the proposed development conflicts, the reasons why, if you like, the strict control is imposed by policy, are the following: protecting the character of the countryside, protecting the character and setting of settlements, and possibly, I say possibly simply because it's in the sporting text, not the policy, possibly also just promoting sustainable patterns of development. Those are the 3 purposes that are very obviously can be derived from that material I've just outlined. And Ms. Greengrass rightly accepted in cross-examination that Recognising the intrinsic character and beauty of the countryside doesn't mean that one should assume all countryside has precisely the same qualities, which obviously it doesn't. Instead of that one-size-fits-all approach, the proper approach, as she agreed in cross-examination, was that the extent to which any particular piece of countryside contributes to character and beauty, and the extent to which any particular development on it will impact on character and beauty, will vary from case to case. It's therefore fundamental that in the present case, the council has accepted that the proposed development would have, firstly, no significant residual effects on the character of the landscape and the townscape. Its impact in this respect would be not significant in planning terms. See the LVIA, which was endorsed in the officer's report. Ms. Greengrass accepted in cross-examination. She accepted that characterisation explicitly. And secondly, that there would be acceptable visual effects. See the officer's report at 7.3.9. And I know that conclusion about the acceptability of visual effects was reached even before the refinements proposed by Mr. Reynolds, whose uncontested evidence demonstrates that the scheme will be of very high design quality, to which significant weight must be given. And so this next paragraph is fundamental, that Miss Greengrass ultimately did accept in cross-examination that this meant the proposed development would not cause any significant in planning terms harm to the stated purposes of the part of Growth 2 with which there is a conflict, namely protecting the character of the countryside and the character and setting, that should be, of settlements. And so I want to just add on the side here that therefore you have to read paragraph 19 of Mr. Smythe's closely with a considerable degree of caution. It's not open to him to submit that material harm is caused and the policy harm affects real harm. His witness accepted no significant in planning terms harm to the stated purpose of the policy. That was a very clear acceptance, not re-examined. Submissions at 19 are not open to the council to make. Returning them to the script, there would also be no harm to the possible additional purpose of promoting sustainable patterns of transport. The statement of common ground notes the agreed position that the site is sustainably located. Mr. Parfitt's unchallenged proof explains why, and Ms. Greengrass reconfirmed this in cross-examination. The lay representations by interested persons to the inquiry related to highways and drainage didn't provide any basis for disagreeing with the unchallenged expert evidence provided by Mr. Parfitt and Mr. Robhill on those matters. I then turn to accordance with the plan as a whole. A fundamental deficiency in the council's evidence in this appeal and its determination of the application of law beforehand was its failure to give proper consideration to whether the proposed development is in accordance with the development plan as a whole. The principles in this respect are well established, but it was clear in cross-examination that Ms. Greengrass was unfamiliar with them. In the Corbett case, the Court of Appeal cited and approved the following passage from the earlier judgment of Mr. Justice Sullivan, as he was then, in the Milne case. And I set that passage out, I highlight the following. It was untenable that if there's a breach of any one policy in the development plan, a proposed development can't be said to be in accordance with the plan. And then 51, the terms of the policy is a relevant factor. So is the relative importance of the policy to the objectives of the development plan and the extent of the breach. Those are the three factors that he says are of relevance. Now, during the course of the inquiry, it was twice suggested by Mr. Smythe on behalf of the council that for this principle to be engaged, there would need to be policies that pull positively in the other direction to those two, as opposed to policies with which the judgment simply complies. I'm not sure if that point is pursued because it wasn't mentioned in closing, but if it is pursued, it's wrong in law, as the judgment of Mr. Justice Holgate said in the Dignity case. Mr. Justice Holgate held that the following proposition could be drawn from paragraph 51 of Mill, which I've just read out. And it said this: the decision maker may consider that compliance with other policies designed to secure that development in general takes place without causing significant harm to a range of environmental factors does involve a greater degree of compliance with the development plan than a non-compliance. So that's what you're looking at, greater degree of compliance than non-compliance. And as Ms. Greengrass accepted in cross-examination, it's therefore relevant in considering whether there is accordance to the plan as a whole in this case to consider the following. Firstly, the fact that Growth 2 is the only policy within the development plan with which the council alleges conflict. Secondly, the fact that the proposed development is in all other respects consistent with and or supported by the development plan. Thirdly, consideration of how serious the conflict with growth 2 is in the particular circumstance of this case. And just pausing there, one doesn't look at it in the abstract, just look at how important is growth 2. It's how serious is the impact in this case. That goes to the extent of the breach, the Mill paragraph 51 factor, and Miss Greengrass accepted in cross-examination that an important consideration in that context is whether there's any conflict with the purposes of growth 2. And as explained, there isn't. And finally, the fact that in the circumstances of this case, the policy conflict doesn't give rise to any significant on-the-ground harms. And we submitted it must also be relevant that the single policy with which there is conflict is one in relation to which Inspector Chamberlain judged only moderate weight could be given to a conflict in that recent Witchford decision due to being affected by the out-of-dateness of growth 1. Miss Greengrass expressed the view in cross-examination that the relative importance of growth 2 to the local plan meant that conflict with policy precluded the conclusion that there was non-accordance with the plan as a whole, and that was a theme picked up by my learned friend a moment ago in closing. In her view, any other conclusion would not only be wrong, but outside the range of reasonable conclusions. And that extremist stance is wholly untenable. It's irreconcilable with paragraph 51 of Milne, where the relative importance of the policy to the overall objectives of the development plan is but one of 3 relevant factors to be assessed in the round. It's not a threshold or knockout point on its own. And whereas here, the breach is in letter only, and there is no conflict with the purpose of the policy and no consequent significant harm, it is plainly open to the decision maker to conclude there is accordance with the plan as a whole, even if the policy is an important one. I note, sir, indeed, the policy in Corbett that was infringed was the Cornish Landscapes Protection Policy. That goes to the heart of the Cornwall plan, that policy, plainly. The Cornish Landscapes Policy is plainly an important and fundamental policy in Cornwall, and that did not prohibit the Court of Appeal upholding the finding of accordance with the plan as a whole in that case. For all these reasons, we invite you, sir, to conclude that the proposed development would be in accordance with the development plan as a whole. And Ms Greengrass confirmed that in the event of such a conclusion, the Council accepts that the appeal should be allowed. She didn't identify any material considerations which would indicate the appeal should be dismissed, despite accordance with the plan. And then thirdly and finally, so I turn to the situation where you were to find there was a flat balance and non-accordance with the plan, and so we're in other material considerations, section 38.6 territory. And in that context, it's necessary, sir, to start with a few words about the approach to considering whether other material considerations justify a decision otherwise than in accordance with the development plan for the purposes of section 38.6. At times during the inquiry, indeed it was picked up in closing, it appears the Council approached section 38.6 on the basis that paragraph 12 of the framework imposes a test that where the tilted balance doesn't apply, a proposed development must be unusual in order for other material considerations to outweigh the development plan. Well, if that point is pursued and seems it is pursued, it's legally unsound and should be rejected. The first sentence of the framework makes abundantly clear that the framework doesn't alter the statutory test on section 38.6. To read that paragraph as putting any form of gloss on the test is therefore untenable. Paragraph 12 is not setting any form of guidance or test that decision makers must adopt when applying section 38.6. It is simply attempting to describe in high-level terms the effect of section 38.6. In any event, to be for the avoidance of doubt, as we said in opening, we said in evidence, this is an unusual case. That effect of section 38.6 is well established. The development plan is the starting point, but is not the end point. As Lord Hope stressed in the City of Edinburgh case, the planning authority is not obliged slavishly to adhere to it. The range of potential other material considerations that are capable of outweighing non-accordance is broad, and a paradigm situation is where the benefits of granting planning permission outweigh the adverse impacts, including the non-accordance of the plan, so that it is in the public interest to allow the development to proceed. Relying on the development plan to resist the proposed development, which has been demonstrated to be in the public interest to allow it to proceed, would be precisely the kind of slavish adherence that Lord Hope deprecated. And yet that is what the council seeks to do in this case. As already noted, in terms of on-the-ground impacts, this appeal scheme achieves just about as clean a sheet as a proposed development on an unallocated greenfield site can do. And whilst there is conflict with the letter of the single development plan policy, Growth 2, there's no conflict with its purposes. In both respects, this is an unusual case. On the other side of the scale, the package of benefits is compelling. Mr. Hill's rebuttal appendix 2, as updated in chief Nation Design, sets out the benefits and the weight he suggests they should be given in tabular form for your ease of reference. And his evidence on the weight given to these benefits wasn't challenged in cross-examination. It's not open for the council now to suggest that his evidence on weight shouldn't be followed. To be very fair to Mr. Smythe, he doesn't suggest that. So it appears that the weightings are uncontested. And I highlight 4 points in particular in these closing submissions. First, the contribution to housing land supply. Even if the council's supply is above the 5-year threshold which determines whether the tilted balance applies, the significant provision that the appeal scheme would make to the council suppliers of deliverable housing sites is an important material consideration to which significant weight should be given. It is clear from the evidence on housing supply that the council's former claim to a healthy 7.2 years was a considerable exaggeration. The council itself has now reduced that figure to 6.68 years, and the true position is very considerably lower for the reasons given by Mr. Austin Fell. The council cannot afford to be complacent, as it appeared to be at times during this inquiry, and the imperative of paragraph 60 of the framework to significantly boost the supply of housing remains important. All the more so when the still adopted local plan requirement will not come close to being met by the end of the local plan period in 2031. As Mr. Austin Fell explained at paragraphs 11.4 to 11.18 of his proof, the local plan will significantly underdeliver on its requirement by the end of the plan period. The current shortfall is 2,732 dwellings. Whilst that requirement figure is currently the subject of the single issue review, it is too early to say what the outcome of that review will be, and in the meantime, the local plan requirement carries the force of the statutory development plan. Secondly, the affordable housing offer carries very substantial weight. As to this, the following points are apt. It is clear from Mr. Stacey's evidence, which isn't challenged, that there is a very significant shortfall in delivery compared to the identified affordable needs, whether one uses the 176 dwellings per annum need figure in the SHMA or the 138 figure in the untested 2016 reports. And as to that, Mr. Stacey's unchallenged view is that the SHMA carries more weight, upon which Ms. Greengrass accepted in cross-examination. Actual affordable housing delivery amounted to just 13% of all residential units in the 9 years from 2011 to 2020, considerably below the local plan requirement. The shortfall stands at 1,205 affordable homes against the need identified in the 2030 SHMA. To make that up in the next 5 years will require the delivery of 417 homes per year. Can I just add this one thing? So it was said at one stage that the 10 first homes weren't really meaningful in the grand scheme of things by the council. Ms. Greengrass didn't really make it. In a situation where the shortfall is 1,205 homes, that's an extraordinary thing to say. And if you're even remotely minded to say that in your decision, imagine saying that to the face of 10 people in need of 10 families in need of affordable homes. Could you seriously say that to their face? Even on the council's own 5-year housing land supply figures, the council's pipeline of deliverable affordable homes is just 168 dwellings per annum, or 164 once right to buy losses are taken into account. In other words, very considerably less than half what is needed to make up the shortfall and ensure that needs are met. Further, in Soham, as noted in paragraph 8.1 of the officer report for this case, the viability assessment report for the abortive local plan suggested 20% was the appropriate affordable housing requirement for market-led schemes on viability grounds. And Ms. Greengrass confirmed in examination the council continues to treat this report as of relevance. And other schemes coming forward around Soham are currently proposing 20% without challenge by the council. The council doesn't require a justification on viability grounds. They take an assertion that 20% is the maximum at face value in light of that report. And as Ms Greengrass stated in cross-examination, there are currently no first homes in the council's housing pipeline. The particular need for this kind of affordable housing product is not currently being met in the district. And it follows, from the above that merely granting schemes that accord entirely with the development plan will not come close to meeting identified affordable housing needs. The appeal scheme, both in its amount and range of affordable housing proposed, is out of the ordinary for Soham specifically and the district generally, and it would do so at the cost of no significant in planning terms on the ground harms. So you asked if the provision of the first homes on top of the policy minimum of 30%, which, as I said, Ms Greengrass has indicated is routinely reduced to 20% elsewhere, if those first homes can be taken into account under the SIL regulations. We say it can be. It's part of the combination of interlinked benefits of the appeal scheme, which we say collectively mean the development is acceptable. I suggest it's not appropriate to salami slice that interlinked package and ask whether each particular slice makes the difference between winning and losing. The affordable housing offer is not an attempt to buy planning permission in the way that, for example, some retail operators used to be criticised for doing. No more than 100% affordable exception scheme would be. It's an integral part of development for which permission is sought. There's nothing wrong with seeking to make the development even more beneficial by increasing the percentage of affordable housing. And there's nothing wrong and everything right with giving that credit in terms of the constant weight to be given to the affordable housing element of the scheme. We've made the scheme better, and it should be credited for that. Thirdly, a further 5% of the homes proposed will be custom or self-built. The council's response that it is simply what the local plan envisages fails to appreciate that in many instances, what the local plan has envisaged in relation to custom self-build hasn't come close to happening. Mr. Mosier's proof, section 6 deals with this, the headline being the local plan allocations have, in half the lifetime of the local plan, delivered only 32% of what was envisaged for custom self-build, a shortfall of between 50 and 60 units. Further, the true extent of custom self-build need in the district has been suppressed through the imposition of a local connection test without the strong justification required by the PPG. It's therefore clear that merely granting schemes that accord entirely with the development plan will not lead to custom self-build needs being met, and substantial weight should be given to the additional contribution that the appeal scheme would make at the cost of no significant on-the-ground harm. Fourthly, development will be of a very quiet quality, and Mr. Reynolds' evidence, which wasn't contested, explained it does more than simply achieve par in relation to design quality. His evidence demonstrates, and Ms Greengrass accepted, the scheme would fall within the terms of paragraph 134A of the framework, and in line with 134, significant weight should be given to this. And fifthly, applying framework paragraph 81, significant weight must also be given to the economic benefits of the scheme outlined at page 56 of Mr. Hill's proof, which again wasn't challenged in cross-examination. And those economic benefits include, but aren't limited to, 180 construction-related jobs, 270 jobs elsewhere in the supply chain, and £5.24 million per annum spending power. Ms Greengrass rightly accepted in cross-examination that in these respects the appeal scheme would support economic growth and productivity. As such, paragraph 81 mandates that significant weight should be accorded to them. It's untenable to read that position as only applying to employment development, as Ms Greengrass suggested in cross-examination, without pointing to any appeal decision or case law. It would also be misconceived to downplay the construction benefits on the basis they're temporary. The vital role the construction plays in the UK economy is wholly dependent on a continuing pipeline of temporary projects. The other material considerations also include the following facts which distinguish the appeal site from many other unallocated sites in the district. Firstly, it's within a broad location for growth, envisaged by the plan as being potentially needed to meet development needs, with no showstopper impacts identified, consistently with lack of on-the-ground impacts now evidenced. And secondly, it was a proposed allocation in the abortive new local plan, which the council unilaterally shelved following the independent examination. So for all of these reasons, sir, this is not a typical unallocated greenfield development. It's one where the on-the-ground harms are as minimal as they get in such a case, and where the package of benefits, irrespective of the 5-year supply situation, is, to repeat what I said in opening, unusual, deliverable, and powerful. The balance of considerations is such that it is in the public interest of the development to proceed. If the proposed development is not in accordance with the development plan as a whole, this is a paradigm case where on a flat balance, material considerations would justify a decision that the appeal should be allowed, notwithstanding any non-accordance with the development plan triggered by the conflict with a single policy, the purpose of which would not be undermined by allowing the development to proceed. So, sir, for those reasons, thanking you for holding the inquiry, we invite you to allow the appeal.
Okay, thank you for that, Mr. Banner. Right, okay, so that's the closing submissions. There has been an application for costs made by the council earlier in the inquiry that was made in writing, and I see that a written response to that has now been sent through. Have you had a chance to see that, Mr. Smythe, in advance of now?
I have, sir. I think I'm entitled to the last word. I just wanted to make 4 brief submissions in response, but yes, I've seen it. Okay,
well, I haven't seen it yet because it's only just been sent through to me, so I need to read it. So I suggest we have a short break at this point so that I can do that, and then I'll come back and hear your final comments on that before we close. Okay, so we'll take 20 minutes, please, and come back at 20 to 11. Thank you. Right, okay, welcome back everybody. The inquiry is resumed. Mr. Smythe, are you with us?
I am, sir. Sorry.
Thank you. Right, okay, so I've had an opportunity now to read the appellant's response to the costs application. So I will give you a chance in just a moment, Mr. Smythe, to give me your final word on that. And I've also noted that the final sentence of that response itself makes an application for costs in responding to the costs application. So you had seen that, I take it, Mr. Smythe?
I had.
Right, okay. I'll come on to whether you want to say anything in response to that in just a moment. So first, in the first instance, could you just give me your final comments on the application made by the council?
Yes, sir. Just 4 points in response. Firstly, in respect to the first paragraph, there's the reference to belated. Straightforward response to that, sir, is the council awaited the round table discussion before reaching a view as to whether to bring the costs application. More specifically, it was after day 1, because day 1 was Windfall and Category A sites. And so that was the reasonable approach to take. The round table wasn't simply a formality going through the motions. Indeed, Mr. K gave up about 0.25% of supply. So I say it can't be, the council cannot be criticised for doing it belatedly. Indeed, the application was sent about 4 hours after the round table concluded. And that's because on day 2, I was writing it during the Category B session, and Mr. K added the emails during Barbara Greengrass. That's the reason why it was sent just after 4 p.m. So second point is in respect to paragraph 6A of Malone Friends' response about that the issue is still relevant even if it's a 5-year supply. So I say that is unconvincing. And I ask you rhetorically, have you ever encountered an appeal where the parties agreed there was a housing land supply, but called evidence and tested evidence as to the extent of the oversupply? It formed no part of the appellant's written case that even if there is housing land supply, the extent of the oversupply was relevant. It was a point, that point was raised for the first time by Mr. Banner during the course of the round table. And finally, sir, the purpose of housing land supply being one of the 2 main issues was plainly because the appellant said there was a deficit. It wasn't a main issue because the parties were arguing about whether it was 7 years or just over 5. So point 3 is in respect of paragraph 6D of Malone Friends' response, making reference to Mr. K giving ground. So I simply observed that fits rather uncomfortably with Malone Friends' closing. You recall Malone Friend described the council's approach to housing land supply as arrogant and hardline, whereas in fact, the council made concessions in the round table of about 0.25 years. And so you'll note that Mr. Austin Fell, notwithstanding 6 hours of round table, didn't give a single concession. He did not give up a single dwelling or unit in his list. Now that may be because he's on very firm ground, or it may be because he wasn't being pragmatic. But I say that is eloquent to the council's approach and being reasonable. and giving ground when they could hear the argument being articulated and seeing there is some merit in it. So finally, it's simply an observation that you'll note at my paragraph 12, I perhaps anticipate a criticism that the council in some way brought it on itself by not engaging. And so you see the emails, Leonard Friend doesn't deal with that point. So straightforward point is that stands uncontested. There's no suggestion that the council in any way contributed to this issue. So that's everything I wanted to say. I don't intend to say anything about Leonard Friend's application.
Right, okay, thank you. So in relation to the appellant's application, I presume that by making the cross application, you consider it is reasonable to do so. Okay, thank you. And Mr. Banner, I assume there's nothing more to be said on your part in relation to that.
No, Mr. Smythe gets the last word, so he's had that last word, and it would be inappropriate for me to comment.
No, I mean in relation to your own application. For costs.
No, it is what it is. We think it was an unreasonable application to make, and we've wasted our time applying to it.
Yes, right. Thank you. Okay, right. That deals with costs. So we're nearing the end now. I'll just deal with a few documents that have been submitted. I had requested an updated position on the 5-year housing land supply calculation. I've received that, thank you, and the amendment that I sought, so thank you for that. Also, the revised set of conditions following on from the roundtable session yesterday afternoon. So I have that, thank you, a track changes version and a clean version, and also a note from the appellant about condition 26, again, followed from the discussion. Does the council wish to say anything about condition 26? Have you seen the note and are you in agreement with it?
Yeah.
Okay, thank you. And there's also been a plan sent through with a suggested meeting point for the site visit. Is that an agreed meeting point? Yes. Right. Okay. Let's make some arrangements for that site visit then. If that's the meeting point that seems logical to the parties, that's where we will meet. Who's going to be attending the site visit, please?
So from the council, Miss Greengrass is still self-isolating. So it will be two people you've never seen before. It will either be Catherine Looper, or Molly Hood. They know almost nothing about the case, so there won't be any help, but they're there to accompany you, so fairness is maintained.
Okay, thank you.
Our side, sir, Mr. Ben Purdy, P-U-R-D-Y from Persimmon Homes, who does have knowledge of the site. He's not in part of the inquiry team, but
right, okay, so those people can accompany me onto the site itself. I will also have a look at the surrounding area of Soham but I can do that on an unaccompanied basis if the parties are content with that.
So I am. So there is one other person. I'm told that Mr. Rose has expressed an interest in attending the site visit.
Mr. Rose, who spoke at the beginning of the inquiry.
Yeah, on day one, so that's right.
Yes. Right, okay. I'm assuming that he's been following proceedings on the live stream. Has somebody been in contact with him?
Yeah, he's contacted the council expressing that interest. I don't know whether he's watched the whole of the proceedings.
Right, okay. Well, perhaps Ms. Greengrass, if you have contact details, are you able to make him aware of the meeting place and time?
Yes, I can make him aware because he did email me. But can someone just tell me where the meeting point is so I can tell him?
Yes, there was an email which identifies that. So that's the council has that. So if you speak to your colleague, they'll provide that to you. Right, good. So in terms of time for meeting, it's just approaching 11 o'clock now. I would suggest 1:30. Would that suit the parties?
Yes, I'm seeing nods. Yes.
Thank you. That's okay with the council, is it?
Yes.
Okay, and just to reiterate for anybody who is watching on the live stream, the site visit is simply an opportunity for me to see the site and the area. So there's not going to be any further discussion of the merits of the case. Evidence is done now, and I'm shortly going to close the inquiry. So you can all be reassured by that. Mr. Rose is more than welcome to attend, and anybody else that wants to, but again, there won't be any discussion. Right, good. Okay, so we'll meet at 1:30 at the place indicated. Are there any other matters to raise before I close?
No, sir. Thank you and goodbye.
Okay, right. Thanks very much then, everybody, and thank you to the council officers who have operated Zoom this week. That's very helpful, and thank you for everyone's participation. The inquiry is now closed.
Thank you. Goodbye.
Goodbye.
Bye, Charlie.